This is Donald Derby as the petitioner, Melanie Vianola as the respondent, and I believe we have guardian ad litem Ann Height with us.
Yes, good morning, Your Honor.
Good morning. So what I believe we are here for, and some of you may know the typical judicial officer who's probably heard a lot of the matters in your case is not here today. So if I am mistaken, please correct me. But what I believe we're here for is to determine a restraining order. Looks like a temporary restraining order, emergency restraining order was signed. Does that sound correct to the party?
Can anybody hear me? This is Melanie, part of the party.
Yes, we can hear you.
Okay, I'm trying to get re-logged in so I can see if I can get 1 second.
Yep, absolutely. We'll give you a minute.
Thank you so much.
Yes, absolutely. And you said you are Melanie?
Yes.
Okay. So does that sound right to the parties that what the folks are prepared to proceed on today is whether this restraining order should be entered?
Yes.
Yes, Your Honor.
Okay. So what I will do in order of how we proceed is, Mr. Derby, I'll let you know what I have reviewed for filings. I'll let you make any arguments to the court that you want to. Ms. Vianola, I will let you respond. And then I am going to get input from GAL if there is input to give on this matter. All right, so Mr. Derby, what I do have is a motion for immediate restraining order that was filed on or about March 21, 2023. And are the statements that you made in the, it looks like the March 20th petition filed on March 21st, are those statements true and accurate under penalty of perjury?
Yes, ma'am.
Okay. So go ahead and tell the court why you are asking for this restraining order to be entered.
Well, at this time, my son had been feeling so scared, and he had been running away. He ran away 5 times. Twice the police were called. One time he was put on a runaway list. The things that he says that had been going on in the home, he's a 15-year-old boy who's over 200 pounds, and he was saying that he was scared all the time, and if they weren't yelling at him and doing whatever was going on, they were fighting with each other. There's a constant feud going on. He'd been getting slapped, punched. He had shoved against the wall. Things were being thrown at him. And he was always saying that if they get around alcohol, then things get even worse. So at this time, I just feel that for him to feel safe and secure and to be happy and just to concentrate about schoolwork and doing his 9th grade work, I feel it's very important for him to stay in the one home until the courts can come to a trial and a final decision.
Okay. And I do see that you have also filed that order for adequate cause, which was granted to more permanently amend the parenting plan. Is that correct?
Yes, ma'am.
And you're just awaiting a hearing date on that, it looks like.
I think it's in May.
Okay.
So I guess I was hoping to have this restraining order in place until May, and then just go by whatever parenting plan we come up with.
Okay. Okay. Thank you for your input. Ms. Vianola, do you object to this restraining order being put into place temporarily?
Absolutely. 100%.
Right. So go ahead and please tell the court why you are objecting to this restraining order being entered at this time.
I'm objecting to it because there is absolutely none of this it's never happened. There's actually a CPS report. Nothing was founded. This is the 3rd CPS report that has been done on us, and nothing has been founded. And we are now going on our 3rd guardian ad litem. And the first 2 were definitely not in the favor of what Mr. Derby's saying. And it's kind of the same thing, only it's progressed. The things he has now accused me of are heinous, absolutely heinous. I work with children, and I could lose my job had anything come of it for any reason. My son, I have not seen in over a month because he is not following the current parenting plan. So I don't really know why he thinks the paper today matters or what he says matters when he can't even follow the current parenting plan. That is a concern to me majorly, that not only have I not seen him, he's withheld him from my parents, whom they have wonderful bonds, and they've seen my son every other week for the past 8 years. And he has not been able to contact any of us. And I've also not contacted Mr. Derby since March 21st. And when I did, it was a message from the school about Driston using his phone. And it was just a photocopy of that and asked if he had seen it. I actually have my father here as well, because I think what's best for Driston, honestly, at this point, is to be out of both of our homes. And Mr. Derby said that my dad's house is a safe place. He loves his grandpa, and it's a mutual ground. And it's a place where Driston can be safe and feel like he can speak freely. And I hate saying that because as a mom, that's the hardest thing to do. But I don't think he's in a good position right now, where his dad has been keeping him from everybody and isolating him completely.
Okay. And I'll just state for the record, I won't be deciding any sort of alternative placement for the minor child at this point. That could be something that you address when you all go to a full hearing on any modification of the parenting plan.
Okay.
Anything else? Yeah. Anything else you want the court to know?
I mean, I really don't, that other than I know that everything he's saying is so not true, and it's slanderous. I've been defending myself for 13 years in this court system. That's all I've been doing. It's not about Driston and what's best for him. I have been defending my character and who I am, and my husband's character, and my oldest son's character. That's all this is.
All right. Thank you for your testimony.
Thank you.
Ms. Height, I know that you recently, at least based on my review, you had some interactions previously in this case and then were reappointed. And I know that was fairly recent, so I'm not sure how far that new investigation essentially has gone. So I'll turn it over to you at this point to see if you have any input for the court.
Thank you, Your Honor. That is the situation. I was originally appointed in November of last year. Adequate cause was not found at that time, and so I set everything aside. I was reappointed on the 15th of March and re-engaged with the parties to see if we could get some traction to get the intake packets returned. I had already received Mr. Derby's packet, and I've been assured in a conversation with Ms. Vianola yesterday that she's going to get that packet and payment to me so that I can get underway. I will tell the court this morning that in my previous appointment, I did speak with Driston at school, and we had a good conversation. He did express at that point some discomfort being at mom's home, but Driston he's a complicated and special young man, and I don't know if it was something that was bothering him that particular day. I got the impression that things change quite often with him. There's seemed to be a fair amount of volatility in the homes, and I think volatility is probably too strong a word. There seems to be some uncertainty and instability for him in his thinking and behavior in the home. So all that to say, I don't have any fresh information. I haven't talked to Driston since I was reappointed. And so hopefully that will get underway soon. My final report is due on May 10th, and I have every expectation that I can meet that deadline.
Yeah, and I do see there's also, unless this has been stricken for some reason, it looks like there is a compliance review set for April 12th. So just next week. Does that sound correct to the parties?
Yes, ma'am.
I've never been served with any papers of that, so I had no idea.
So this was set during a March 15th appearance where I'm just looking to see if you were present. It doesn't look like you were present.
I missed it because I received in my filed papers basically a judgment that had already been made is what it looked like, but it had not actually been filed. So I thought a judgment had already been made. My mistake for not looking further into that. But yes, I did miss the court date. So
So yeah, and so I would let you know what the court does have, based on that March 15th hearing where you weren't present. They did set a compliance review for April 12 at 9 a.m.
okay.
Your Honor, I'm just wondering if, in view of the fact that I have spoken to both parties since I was appointed and have had assurances that I have one intake packet and I have the assurances that I'll be getting the other one shortly. And I don't believe payment is going to be an issue either. If it would be worthwhile to strike that, I would say at this point, as far as we could have gotten by now, we are in compliance. And I
Okay.
don't anticipate a problem getting the other information that would be reviewed at that time, although I'm perfectly willing to come back next week.
How did well, yeah, let's come back to that issue. This is what I couldn't see. I do see the order regarding adequate cause granted to send the parenting plan amendment to a full hearing. Has there been a date set for that full hearing? I know, Mr. Derby, you mentioned something in May, and I'm just not seeing that.
They said May 3rd, but I'm not sure if that was actually set in stone.
Okay, let me check with the court. Let's do this, just because I think there is not a date set yet for that full hearing. And Commissioner Nelson would be the one handling the April 12th compliance review, just to kind of make sure we're ready to go. Let's go ahead and keep April 12 at 9 a.m. I'm sure it can be, very brief, just to determine if we're ready to set that full hearing date. And then the parties would note this for an actual hearing date.
Just to see your son.
Okay. Now let's go to the restraining order. Ms. Height, do you have any input to the court as to whether a temporary restraining order would be necessary to protect the minor in the meantime? And I see that the court issued an emergency one. I'm kind of in a position where it's essentially he said, she said. I don't really have any documentation in front of me. So, and I do see the prior parenting plan based on a full GAL investigation at that time did not put a restraining order into place. So any thoughts or input from you?
I don't have any recent contact with Tristan, and
Okay.
this week is spring break. I would have preferred to speak with him at the school, where I think I would have a little more forthcoming conversation. So my hope is to speak with him next week. So all that to say, Your Honor, I don't really have any fresh information that I think would be helpful this morning.
Okay. Well, here's what I'm inclined to do. I think because the prior commissioner put an emergency order into place, I am going to temporarily re-up that until there can be further investigation. The reason I'm doing that, Ms. Pianola, is not in any way to say that I necessarily am making any ruling on the veracity of the statements that are made, but I do think it makes a lot of sense to have this further investigation and have Ms. Height be able to talk to the child before we make any permanent decisions on that. So what I'm going to do now is actually go back and reverse my prior ruling on that review date. I think what we should do is set out the review date a bit further, and then I'll make this restraining order temporary only through that review date. So it would essentially be a new compliance review date as well as a review of the restraining order. And hopefully at that time, we'll have a little more feedback as to whether this needs to be a longer term restraining order or not. So with that said, I'm kind of thinking 2 to 3 weeks at most. Ms. Height, what would be your preference?
Well, in view of the fact that everyone wants to get some stability for this young man, I think the 19th would work. If that would be 2 weeks.
Yeah.
And what I will attempt to do is have contact with him, and then I would like to file a brief written report, just really an information for the court so that everybody's on the same page when we come back on the 19th. So it might come in later than I normally would like to. I would like to file it 3 or 4 days ahead of time, and I will attempt to do that, Your Honor.
Yeah, that makes perfect sense, and I appreciate that. And I think, so Mr. Derby, Ms. Vianola, instead of coming back next week on April 12th, I'm inclined to strike that and instead reset this for review, both compliance and restraining order for April 19 at 9 a.m. Does that work for the parties to log back in here Wednesday, April 19 at 9 a.m.?
Yes, Your Honor.
Okay. Ms. Vianola, does that date work for you?
I mean, I haven't seen my son in over a month. Is there any way I can do a supervised visitation with him with a mutual or a parent's place? I think it's really difficult to say that it's fair to Driston or to either one of us that he hasn't seen me, and not just a month. That's just been solid, has not seen me, but it started 6 months ago.
Yeah.
And now this is actually my spring break. And that's a long time not to see your mother and be isolated from both parties. And now I can't have any contact with him without any valid, I mean, even a CPS report was done and nothing was found of it. So
excuse me, Ms. Vianola, does Driston have like FaceTime capabilities on a phone or some other electronic device or a device that he could access? Because I am inclined to allow electronic communication, because then I know that it's his wish to, reach out to you. And I think that's very valid for the next
in our
2
parenting plan, he does have that right.
Yes.
Unfortunately, I don't get to talk to him on the phone. I only get text messages, and I know how Driston speaks, and it is not Driston. I can't guarantee who I'm talking to, and he hasn't called my parents. He hasn't called anybody. So I have a hard time believing he has free access. Mr. Derby will say he does,
Okay.
but I can't guarantee that.
So Mr. Derby, what I am inclined to write into this very short-term 2-week restraining order is that all forms of electronic and phone and video communication will be allowed. And I really do recommend that you allow that to occur, and that you allow that to occur privately, where you're not standing over the child and the child doesn't feel like they have to please both you and Ms. Vianola, that this is time with his mother. Is that something that you can make sure happens?
Yes, ma'am. He has his own telephone and his own number, and she has it. I ask him all the time if he wants to call his mother. He says no. He absolutely does not want to. I'm doing this for him. In the prior cases, he's been so young that he wasn't able to really say what he wanted. And now that he's actually getting older, this is why this is occurring again, is because he's actually able to tell the truth of what's going on. But he has his own phone number. He has it with him 24/7. So even at school, he has it for any kind of an emergency calls. And everybody has his phone number.
Okay. So I am writing that specifically into the order. So Ms. Vianola, all forms of electronic communication, including phone, text, email, FaceTime, those are allowed. And I would encourage the parties to do that, to keep that parent-child connection through this rocky 2-week period that, we will get through. And we'll be back here on April 19.
I do have a question while you're doing that really quick. Would it be possible to meet at his school during a free hour with his caseworker during the day? If it's a free hour?
And someone's trying to speak over you.
I hear that. Sorry.
If you're not actively in front of this court on a case right now, please mute. Otherwise, the court will mute for you. Go ahead, Ms. Vianola.
So I know Mr. Langenbach is his caseworker at school. I know he has 2 periods, or he was having 2 periods with him. And he also has a counselor that I had, asked them to kind of check in with him periodically because of everything. is it possible that I could meet him at the school with the counselor? And if it's a free time, lunchtime, if that is something he would like to do during these 2 weeks, I don't want to step boundaries where I don't know what my restraining order is, other than I can't be within 50 feet of him.
Yeah, I think I understand what you are asking. And I think just for this 2-week period, I'm going to leave it as no in-person contact until the court has a better idea of what exactly is going on here and what the wishes of the 15-year-old are and what the concerns potentially are. So hang in with us for these 2 weeks. You know, I'm going to put in the exception for electronic communication, but I'm not inclined to do any in-person contact at this time.
I want the courts to really know that Driston, you know, he is, like the GAL said, unique, and he's functioning not at a 15-year-old level. He functions at a 6th grade level. And his doctor's notes say that, his teachers say that on the new IEP we just did. So it's very important to remember that, yes, normally a 15-year-old, you know, can be very capable of making these kind of decisions or understanding things. He is not 100% there.
Oh boy, see, this is why he needs to get away from her.
I don't find it funny. Sorry, Mr.
Oh.
Derby.
No,
I'm
it's
gonna have to meet some folks here.
I already filed it all.
Okay. And again, I certainly understand the concerns. I do hear you. It's not falling on deaf ears. I just, I think that given where we are at and the fact that we can get you folks back in 2 weeks, I'm just going to leave it as is now with electronic, phone, video, all of that strongly encouraged, allowed and strongly encouraged. So Mr. Derby, I hope you're hearing me say that I am hoping that Ms. Vianola and her son stay in contact electronically through this 2-week period. I think that will be important for both of them.
Thank you.
And then I'm going to check the box on this, that because you were both here, although virtually, that this restraining order doesn't need to be served on you, Ms. Vianola, by law enforcement. I think that's kind of overkill in this situation. But what I would encourage you to do is anytime later today, reach out to the clerk's office or come by the Superior Court clerk's office and get a copy of it.
Okay.
Because then if any issues come up with, you know, was electronic communication allowed, that sort of thing, you're going to actually have that in hand.
Okay. Thank you.
Oh,
Yes, sir. I saw you raise your hand. Go ahead.
I was just was going to let the courts know that she was served by the sheriff's department.
And sir, what I'm talking about is this order that I'm currently signing. This one is a little bit different than the urgency order that Commissioner Nelson signed, because it does allow that electronic communication. It also gives a specific expiration date of April 19, 2023 at 9 a.m., which is when you folks will be back in front of this court. And I will make sure that Commissioner Nelson, he will see it in the notes, but I am going to shoot him an email just to know that this is also an issue he'll need to address on April 19th if this restraining order needs to be re-upped, because the default is going to be that it lapses on April 19th at 9 a.m. Okay, I've got that filled out. I'm handing that up to the clerk. I really appreciate everyone's time and patience. We'll get through this. We'll get you guys some resolution, some stability, some finality. Okay.
Thank you very much.
Your Honor.
Thank you.
Yes, go ahead. Yes.
Might I ask the parties one quick question, just kind of a housekeeping?
Of course.
I have a phone number for, I believe it's Driston's phone number that ends with 2399. Could somebody verify, either one of you verify that for me?
I think that was the phone number we had for him.
Okay.
Let me see.
And if you don't want to say it publicly, you can text it to me.
I'll
Is that with the 360 at the beginning?
Yes, ma'am.
What was that number? We don't have it. None of us do. Me and my dad don't have the correct phone number.
He talks to Lee.
No, he doesn't.
It's 360.
Thank you.
Well, good, Ms. Hyde. I'm glad you asked that question, because it sounds like that information needed to go to all parties. So thank you.
That's not
okay.
True.
If there's nothing, Mr. Derby, did you have something you wanted to say?
I just wanted to say that everyone has had his phone number. That's all.
All right. All right, parties, thank you for your time and you're free to log out. We'll see you back on April 15th at 9 a.m.
Thank you.
Marissa Shoemate, I saw you log in. You are present.
Yes.
Okay. And then we have Beth Fellows, I believe, as the GAL on this matter.
Yes, Your Honor.
Perfect. Thank you for being here. I somehow have lost some folks. Yes, thank you. So you are Kyle Weeks, and we have Chris Shoemate here. So again, I'm kind of getting up to speed as the commissioner filling in today, what I believe we are here for. There's several things happening in this case, but what I see today's hearing is for is a contempt review. Is that the understanding of the parties?
I just got the documentation yesterday, so I haven't really got the chance to read all of it.
And Ms. Shoemate, which documentation are you referring to?
The contempt.
Okay, well, so help me understand that a little bit, because my understanding is you all were already here where Commissioner Nelson made some rulings on contempt and specifically gave you some deadlines for things like removing videos from TikTok of the minor child. So help me understand what you mean when you say you just got documentation.
I got, he served me more papers.
Let me grab what I have on this case. Are you, I have amended contempt hearing orders. So the clerk is helping me understand a little bit more. It looks like more recently, as of just a couple days ago, there on April 3rd, so 2 days ago, had about almost 40 pages of affidavits filed. And then Mr. Weiss, I'll also say I did get a USB drive from you that purports to be, I think, the seatbelt issues. Maybe, Ms. Fellows, did that go to you also? Because
yes, it did.
It did. Were you able to open it and review it?
Yes.
Oh, I may need to rely on your review a bit. I tried last night, so they don't let us put these into the court computers. So I had to take it back to my private office and review it there. And it kept saying that the program wasn't accessible and it would not let me review it. So I will let the parties know, while I have this USB, it is not something that I've been able to review, but I have reviewed pleadings. I've reviewed Commissioner Nelson's prior contempt rulings in this case. And I did review the April 3rd filings because I thought that was something we were discussing today. It looks like there's some overlay where I think those additional filings are discussing the prior contempt rulings and some responses and potentially some new information. Ms. Fellows, I think I might go out of order here and turn it over to you first to help me make sense of any recommendations you have for how we're proceeding today.
I will try. I believe that, let's see, we were in court on March 8th. That was basically a review of Vincent Taylor, who is the significant other of Miss Shoemate, since there are extremely concerning criminal charges that he's facing in Skamania County. So at that time, it was ordered, it was recommended, I recommended, and it was ordered that the mother have professionally supervised visits, that it was to be in the local area where the child lives, which is in like the Clackamas, Oregon area. And the father was to find a place and let the mom know, and then hopefully that there would be supervised visits set up, and there would have been a couple of visits from that point until this court hearing. So I think that's what this review was set for. There was also the contempt charges and things like that that were to be basically amended. And it was, the court did want the father to give more specific information. And he did provide that. And then I did get that video for the seatbelt because that was an issue. So that's kind of what we're here for.
Okay. So let me start with the parties, maybe on something that I would think might have a yes or no answer, but I'm guessing doesn't. And so I'll start with you, Mr. Derby, or excuse me, Mr. Weiss, throw back to the prior case. Mr. Weiss, are you aware of whether the TikTok video you were concerned about has been removed?
I am aware that it is still posted as of today. It has not been removed.
Okay. So, Ms. Shoemate, the court was very specific based on my review of Commissioner Nelson's notes that that was to be removed by today's date, that you've already been found in contempt for having it up, and that we were giving you this additional time to remove it.
And it has been removed. I don't know what video he's talking about because I went through and erased any videos that could go as inappropriate for her age at all. And I went through and erased it. I had my sister help me.
Okay, so I guess the court's in a little bit of a bind because I have one party saying it's still up, another saying that it's been removed. Someone help me out here with some actual evidence of whether this, and I think the video that Commissioner Nelson issued a contempt on was a very specific video involving the child. And I can pull up his notes and give the parties more information on that.
I believe that the ruling was that the social media accounts were to be taken down, not just a specific video, but that any of social media accounts were to be taken down, period, end of story.
And I do think that is much more clear. So Ms. Shoemate, where are we at with the social media accounts of the minor child?
I did try to delete the TikTok, but I no longer have that number that's associated with it.
Like,
and
well, hold on. You made that argument last time you were in front of Commissioner Nelson and you were given specific, I guess there was a lot of discussion about how that probably is not a very accurate answer. So let's start over and tell me why the social media accounts are not deleted. There's always a way to go in and delete an account. You can recover a password. You can.
I got through. I finally got on her account with the password, but I tried to delete it and it wants my old number where I no longer have because it sends a code.
Have you reached out to customer service? Have you made any further attempts besides just, well, it doesn't work?
I've been trying to find the customer service on how to contact.
Okay, so what I'm going to do is find that you're still in contempt of court with regard to the social media accounts. We'll give you another 30 days, and at the end of today's docket, we'll find a new date depending on how many issues we need to discuss. But this will be your second contempt finding with regard to social media accounts of the minor child. And I will make a ruling to that effect. I believe, was it that he wanted additional information on the seatbelt issue? Is that why the USB was provided?
Yes, I believe so.
Okay. Mr. Weiss, how are you wanting to move forward on your request for contempt regarding the properly fitted seatbelt issue? Mr. Weiss, are you still with us?
I am. Can you hear me?
I can hear you now.
If we can get the situation addressed in this court hearing today, that would be awesome.
Okay. So help me understand just a little bit. And again, I know it's a somewhat difficult position since I didn't hear the original contempt, but the notes I'm showing state 3 contempt issues. So this was from your last hearing on March 1st. Court addresses parties. There's 3 contempt issues: driver refusing to provide required info, social media not being removed. Court accepts unable to remove for now, set over 1 month for that issue only. If not removed, daughter needs to delete account. And then there was also, the court did find contempt regarding the unknown driver information and exposure to romantic interest and issued the $100 contempt penalty. So it sounds like even though I don't think there was an explicit ruling on the contempt for the seatbelt issue. Does that sound correct to the parties?
That is
Yeah.
correct. I had
Okay.
brought 5 contempts on that hearing, and we were only able to address 3 of them. So we're trying to get to the other ones that weren't addressed.
Okay. So I have some amended orders here. So let's move on then to this. The next one I have in front of me is the seatbelt issue. And let me first turn it over to Ms. Fellows, since you were actually able to review that video and give me some input. I have read the filings. I've read Mr. Weiss's attachments where he's citing seatbelt laws and what he thinks didn't comply with seatbelt laws. But Ms. Fellows, I'll turn it over to you.
Yes, Your Honor. I was able to view the jump drive, and it is clearly Taylor. And she is in the car, and the seatbelt is right directly across this way. So it's across her neck, and you can tell that the car is moving because you can see her kind of moving like this, like car, and the seatbelt is absolutely right there. She does not look like she's slouching or anything else. It is absolutely a definite concern that the seatbelt was not positioned correctly, not even remotely correctly.
Ms. Shoemate, any response to that?
She does slouch. She doesn't like sitting straight, especially going on long drives. She doesn't like to sit up straight. I'm constantly telling her sit up.
So what I did find in this case is that specifically the court has required that seatbelts be properly fitted. This is a huge safety issue for kiddos. Tons of research on this, tons of studies. I will find, based on the documents I reviewed, Mr. Weiss, as well as, I'm not sure who's making all that noise. Mr. Weiss, I'm gonna mute you because I think that's coming from your end. Yep, it was. Okay. I will find that this is while seemingly I can understand folks may see this as a minor issue, I do think it is a big safety concern, that we really are dealing with things that directly impact the health, safety, and welfare of a child. I will order contempt on that issue as well, given the evidence I've reviewed by way of documentation based on Mr. Weiss's testimony and based on Ms. Fellows' statements as to what she was able to observe on the jump drive, even though I was not able to access it. So that will be a separate $100 civil penalty in addition to the prior contempt. And Mr. Weiss, I'll note for the record, I think in the social media contempt order, you had added the $65 for service of contempt. And I will include that in the contempt order. I do think that's a valid cost. Then we're going to move on to the third order I have in front of me was Taylor Weiss was left alone with Vincent Taylor during Christmas break of 2022, allegedly in violation of a court order stating child is not to be left alone with any male except father at any time. And Ms. Fellows, to the best of your understanding, I don't see that this is one of the contempts that Commissioner Nelson specifically ruled on. I think he discussed perhaps bringing a restraining order instead if there were these types of concerns, but I'll turn it over to you to provide some clarification if you're able.
I really don't have any clarification on Taylor being left with any other male. I know that there's concerns about it, but I don't have anything solid enough to be able to stand on to say that this did indeed happen or not.
Ms. Shoemate, are you able to advise the court under penalty of perjury whether you've left the child alone with Mr. Taylor?
No, she has not been left alone with him. He did come help me a couple of times with my car issues, and that was it. She was never left alone.
Mr. Weiss, is there any additional? I did again review the pleadings you provided where You state that you believe this has occurred. Do you have any additional evidence for the court?
Other than the accuracy of what my child had told me and everything I was able to find out was accurate, no, all I have is what I provided.
Okay. I think more probably than not, I cannot find that this issue rises to the level of contempt, as I can't, again, more probably than not, substantiate that it occurred. So I will deny the contempt order as it relates solely to the issue of whether the child was left alone with Mr. Taylor. So that one will be denied. Okay, so we've got those three issues out of the way. I'd like to let me go back to the calendar, see when you folks are back in front of this court on any other issues. The court will be reviewing the professionally supervised visitation for the mother and whether that has occurred. Does that sound correct to the parties?
Yes.
Yes, on top of child support.
Okay. So I'll just so the record's clear, next week we will have the court review those two issues. And then what I'd like to do is set you all out 30 days for a continued contempt hearing on whether the social media accounts have been deleted. Ms. Shoemate, it's my strong suggestion that you reach out to the companies if you're not able to get into the accounts, certainly letting them know that there's a family law case pending and these accounts must be deleted. If there's an order from the court that is needed, we can get that for you, but I do want you to reach out to those companies and get that done. I show 30 days out as our May 3 docket. Does that work for you, Ms. Fellows?
Yes, it does, Your Honor.
That date, again, so the notes are clear, we'll specifically be reviewing any follow-up on the social media deletion contempt issue. Anything else from the parties today that we need to review?
No.
No, not on my end.
Okay. Stick with me just for a minute as I review the drafted contempt orders and find them in case I have any questions for the parties. Okay? Section specifically as it relates to the contempt on the seatbelt issue, where it asks the court to determine if you're able to follow the orders now, meaning moving forward. So can you let this court know if you have plans to accurately fit the seatbelt moving forward?
Yes.
Okay. So I am going to find that you are willing and able to follow the parenting plan. And there is, if you need resources for properly fitting seatbelts, obviously, I believe fire departments still do that. There's lots of resources online, YouTube, those sorts of things. I'm not going to put a review date on the specific allegation of the seatbelt issue. It is my sincere hope that Ms. Shoemate will correct that. Obviously, Mr. Weiss, you could bring a new contempt motion should that not occur. So I've signed that order and it does require a $100 civil penalty for the contempt. And then on the social media order, that one will be $100 civil penalty plus the $65 for service of documents. Right now, I am going to find that you are still not in compliance, so not able and willing to follow the orders of social media. We're going to set, this one's going to have a different review date. Instead of no review date, we are going to review this on May 3rd. Okay, there's nothing else from the parties on this case. I have those three orders finalized and the parties will be back next week. It sounds like for a review on the child support and visitation issues, and then back on May 3rd. Hello, Mr. Nelson, I see you present. Hello, Ms. Milborn, I see you present. Thank you for being patient with us as we work through this docket today. I have, I'll tell the parties what I have reviewed in this case. So going way back, I have reviewed the original parenting plan final order that was entered and signed on November 16, 2022. I also at that time saw that this issue of schooling had somewhat been addressed, and I can go through that in more detail when we get into argument on this case. But I did see that there had been a petition to modify on November 16th, 2022, specifically related to allowing the child to go to school in Kelso. I will note that the exact location of schooling, although that motion was filed, was not entered in the final order, which is why we're here today. I've also reviewed the motion for adequate cause. I've reviewed the proposed parenting plan that was filed on March 21st of this year. I've also reviewed the declaration affidavit of Nicholas Nelson filed on March 21st. That was accompanied by this note for motion docket. I've reviewed Ms. Milburn's response, which was filed on March 22nd with this court. I've reviewed the March 22nd proposed parenting plan by Ms. Milburn. And I've also reviewed Ms. Milburn's declaration affidavit, which also included some attachments, as well as a handwritten note from 3 individuals that I believe are related in a grandparent capacity. So my understanding, folks, is that we are here today solely to determine if there's adequate cause to set this case for a hearing, in which case the folks would be arguing about the sole issue would be where the child should go to school. Does that sound correct to the parties?
Yes.
Okay. So Mr. Nelson, I'll have you go ahead and give brief argument on why you believe there's adequate cause to move forward with this modification. I might call it a modification / clarification of the original parenting plan from November of 2022.
I believe in the original parenting plan that the education portion of that was joint decisioning, and on there we had marked that if a resolution could not be reached amongst ourselves, then we would resolve the dispute in court. So is that what you're looking for? Sorry, I'm new to this.
I mean, anything you want to give the court. I did see that. I guess my looking through the files, it looked like there was some intention for the parties to at that time decide that the child was going to go to school in Kelso. That was in a motion filed the same day as the parenting plan, but then the parenting plan didn't specifically incorporate that language. So it sounds like it was contemplated by the parties back in November, not incorporated in the final parenting plan, and here we find ourselves addressing this issue. Does that sound correct?
Yeah, that's correct. It's been a verbal agreement amongst ourselves that she would be going to Kelso, and you can see that in her declaration that she had previously agreed to it, but now it's time to enroll in school, and she wants to have her go to school in her district.
And where is the child primarily residing, or are you folks still doing essentially 50-50 residential? Where's that issue?
There's no primary residence. We do 50-50 week on, week off.
Okay. And then, as I understand it, the child is currently in Ms. Milbourne's school district.
She lives in both of our school districts. Yeah.
Sorry, meaning the school or daycare that she's attending now is in the district where Ms. Milbourne has an address, correct?
No, she doesn't currently go to any preschool anymore. We'd intended to enroll her in the Kelso district, but because of our daycare, we were not eligible to do that because they did preschool there. She's now no longer enrolled in any preschool or daycare.
She has went to the same daycare for the last 6 years, though. Her date just ended less than a week ago. Just because it's over $2,000 for all 3 of my kids once I have the baby. And so I can't afford that. So she has been there the last 6 years previously. That ended March 31st.
Yes, okay. But we also intended to enroll her in the Kelso preschool, the pre-K program, but we were not able to because of that.
Okay, so she, up until this March 31st day, so just a few days ago, she was in daycare in Ms. Milbourne's school district. Okay, and then the school that Ms. Milbourne, you're contemplating is where a lot of those kiddos from that daycare then go to school, given where they reside. And Mr. Nelson, your request is that once she starts schooling, would this be kindergarten that she'd be starting?
Yes, that's correct.
Okay. And are we talking about enrollment for fall of 2023? So August, September coming up?
Yep.
Yes.
Okay. Okay. I think I have it all clear. Ms. Milbourne, I'll turn it over to you. I guess my question for you is whether you agree that there needs to be a court ruling on this issue, or whether you're asking this court to deny the request for an adequate cause hearing.
It's kind of a catch-22 because in our parenting plan, it is put that we go straight to court if we can't find a resolution, just because on his end, he's unwilling to speak with me or come to a conclusion outside of court. And so that's been what we've done because there's no way to agree outside of court. So I can't really say to deny it because we do need to figure something out so she can get, she's currently enrolled in CVG. When it came out for enrollment, I did enroll her since she's in the district and she's been approved to go to CVG. So we're just waiting for the court, I guess, to rule based off our declarations and whatnot, what's best for her.
Right. Yeah, I see where both of you are coming from. And so there's on these adequate, here's what I'll say. I do think that this does need to go to a hearing so you folks can fully present your arguments about which school district the child should reside in. I do see that there's some ambiguity in what happened back in November of 2022, where the final order gave both of you joint decision-making on education and did not specifically list which address would be used for school district purposes. But I saw the same day, the commissioner had signed an order for modification that had specifically put into language that the child would be going to school in Kelso. So that wasn't put into the final parenting plan, but it was something that was signed the same day. So I do understand the ambiguity. I also understand the current argument that this is where she is now or has been, and this is where friends are going. So here's the two options. I mean, I am going to find that this should go to a hearing. There's one of two boxes I can check. One is we held an adequate cause hearing and I found there was adequate cause, or that the parties agree there's adequate cause and want this to go to hearing. So what I'm first trying to flesh out is whether both of you agree that this should go to hearing or whether you're asking me to make that determination.
I mean, I agree it should go to hearing.
I think it should go to hearing.
Okay. So I am going to check the box and I would agree that there's adequate cause. So I think you both are making the right decision here. I'm going to check the box on the proposed order that Mr. Nelson submitted stating that the parties agree there's adequate cause, which just means valid reasons for the case to move forward. The court does have jurisdiction over this case. The parenting plan was made by a Washington court and we still have authority to make orders for the child, specifically because you folks still live in this district and the child resides in Washington. The court can decide adequate cause because the motion was made by a party. There is adequate cause to hold a full hearing or trial. The parties agree that there's adequate cause. Adequate cause will be found. We did, on the amended order, sir, you had checked that the full hearing would be scheduled at a later date to be set by the court. I am going to leave that as checked, and then what you folks will need to do when you are ready to have that hearing date set. So much like when you were in your original family law case, you would have to note it on to get a hearing date. You know how to do that process?
I do not.
So when you contact the court clerk's office, Superior Court clerk's office, there's a method by which you fill out a paper saying, hey, we want to go to a court date. We want a court date where we go in front of a judge and that judge will set a hearing date for you. So it's not quite as simple as you folks giving a hearing date today. You actually will go to a specific court date purely for the purposes of finding hearing date that works for both the two of you and for the judge or commissioner that will hear it. Okay. And I would say this because we want this decided before August. I'm signing this order today. So it's something that Mr. Nelson, you could do later today or tomorrow to try and get that hearing date set as quickly as possible.
Oh, I'm sorry. I was under the impression that by checking that box, we'd be able to establish a future hearing date now. So what do I need to do? I need to go to the clerk's office and pick up a form. Do I need to have her served with this or?
Well, I mean, technically, yes. I would encourage the two of you, because you both have agreed that this should go to hearing. I just encourage the two of you to work together if you guys have proposed dates to give the court that work for the both of you, this process will go much smoother. Okay, the clerk has just let me know that I can circumvent at least step one for you. So when would be a date that I could set them for trial assignment? So, for both of you, would the two of you be available to log on to what's called our universal trial assignment docket next Wednesday at 1 o'clock?
Yeah, I'm scheduled a 12-hour shift, but I can just let them know and I can take a extended lunch or something.
Okay, and those dockets are usually pretty quick because it's all folks like you who are just requesting dates from a judge. So there's not a lot of lengthy argument like these dockets do entail. So Mr. Nelson, does that work for you next Wednesday?
Yes, universal trial assignment docket at 1 p.m. next Wednesday.
I'm going to put that into this order specifically. Thank you for pointing that out. I think that makes everyone's life easier. Folks are free to log off. Best of luck to both of you.
Okay, thank you.
Thank you.
Hello. So my name is Commissioner Jill Carmy. I'm Commissioner Jill Carmy. I'm filling in for Commissioner Nelson while he's out this week. And we are here for the 10:30 minor guardianship docket.
Fast filing for Guardian Leiden.
Thank you. Looks like we have the folks present. Here's my, and maybe I'll refer back to the parties to get their input. But what I see is that Commissioner Nelson had extended the emergency minor guardianship through April 8. There is a full guardianship matter pending, and you all are on for readiness today at 11:30 with Judge Hahn. Looks like you're going to have probably a one-day fact-finding full hearing sometime next week. Does that sound right?
That does, but things have changed since yesterday.
Oh, since yesterday. Okay.
Yes. So Angel Fisher is requesting an attorney now. And I know that we're kind of limited. So I did let her know that potentially it may take a little bit longer for that. She is wanting to change the potential guardian.
Okay.
So she wants to talk to a lawyer to make sure she's getting the right information to do that.
Okay. And so I assume that will, because I did see the JL report come in for readiness this afternoon, I'm assuming that may change those things a bit as well.
All of it. All of it. Yes.
Okay. Okay. So what I'm going to do here today, do we have forms for the appointment of attorney?
Yes, but we have to find one first. I know that Erin Winkles takes children. I just don't know if she can be involved in this case. So I think for them.
Okay. Got it.
Your Honor, also
Yeah,
Kurt Agnosis, he also does minors as well.
Oh, okay. Kurt and Aaron.
Yeah, those
Okay.
I think those are the only two last I heard that we're taking on minors.
Okay. So we're going to do a couple things this morning. And for the other parties that are present, is there any additional information you want to give me before I formulate our plan, at least for the emergency guardianship?
I have some things. I had some things that I would like to say today. I'm concerned about the communication that has taken place between Vashti, myself, and Angel. And through all of my observations, I'm finding things that concern me. When I talk to Angel,
Your Honor, he's not actually a part of the proceedings, and was given the information to apply.
Right. So, sir, can you fill me in on what your current role is in this case?
I've had Angel in my home for the past few months, and I've had permission to have her in my home by Rose and Nancy Coolwin, who I believe are currently her caregivers, although they're not doing the job.
So, sir, have you filed anything formal with the court?
I haven't. I'm a bit unclear on how to go about doing that. And when I communicated with Vashti on Thursday, she gave me quite a bit of paperwork. There was 20 to 30 documents that I would have needed to go through.
Right. So, sir, what I would say at this time is right now, what we are here on is for review on the emergency minor guardianship case that former Commissioner Nelson has already signed. I can't today take testimony from you. I have no filings from you. I have no sworn declarations from you. So I'm not going to take additional testimony from you at this time.
Is there a reason why I haven't been thoroughly researched and investigated by Vashti?
Sir, I can't answer that for you today. You're not.
Okay, is that something that I can?
Sir, how about that? Let's start here. Can you give me your full name?
My first name is Nicholas. It's spelled Nickolas.
Okay. And what's your relationship to the minor guardian here?
I was in a relationship with Angel Fisher's mother for 3.5 years. When she died at the end of August, I was really emotional and I took an interest in the kid's life and got a hold of them and began communication.
Okay. So, sir, what I would need you to do, so for today's purposes, I'm not going to accept any testimony from you. If there is something that you feel needs your involvement, you would need to file that with the court. Okay, and I can't be on that and give you any legal advice.
I know you can't give me legal advice. I will seek it out.
Okay, so I do see Rose and Nancy online. Is there any input the two of you have as far as we proceed today on the emergency minor guardianship review?
Yes. Our position is that we love Angel and we just want her to be stable. We want her to have like a stable life. She's never really had that. And we were honoring her wishes into staying at that place, but it's turning out to be chaos and he's not a very safe person, it feels like to me now. And so I really just want to pick her up and bring her back to my house, but she probably won't come. That's the thing, but we just really want good for her. We want the stable place. We want her,
Mr. Hub,
you know.
well, hold on one second. As I understand it, and forgive me, I'm filling in today for Commissioner Nelson. So I just am trying to get some background information. So the minor guardians, as I understand it, it does not include Mr. Hubsky, correct?
Not at all.
Okay, so Mr. Hubsky, what's going on? The people who are legally in charge of this minor are saying return the minor.
Because I don't want to go there. They gave me permission to stay here and I feel stable here.
Well, they're rescinding that and they are the guardians in charge right now.
Well, what if I didn't want them to get guardianship?
Nancy, go ahead.
So Angel is a chronic couch surfer. She's been that way for at least a year or so before her mom passed away. And we tried to keep track of where she was at. She comes in and out of our house, but she will not stay there. She said she would stay at Nick's house. So 2 weeks ago, we said that that might be an option, but I haven't spoken with him since then. We would love to have Angel come stay with us, but when we bring her into our house, she just walks away. She has quite a few houses in the area that she surfs from, and a lot of times we don't know where she's at because she doesn't communicate with us when we message her on her phone. So we're just struggling to try and give her a safe place to live.
I would like.
Okay.
I would like to speak again.
Go ahead.
The thing is, we were working together with Nick for Angel, but he started being two-faced. Like he literally was telling Angel that we're trying to steal her baby, we stole her money and stuff like that. We don't care about that kind of stuff. Like Nancy's been providing for this family for literally all her life, you know what I mean? And so we're not out to get her money. We love Angel. We want her to be stable. She's pregnant. We want her to have a stable life. Like she's never had that. And so when he's going behind our backs and to our face, he's really nice. And then behind our backs, he's saying, they want to steal your baby. They're calling CPS on you. They're doing this and that. That makes me feel like she's not in a safe place. Like they're not, you know what I mean? Like I'm a little upset about that.
Yep. So in the difficult place the court is in sitting here today is this is obviously, and as I understand it from Vashti, this is all stuff that has recently come to surface. So understandably, it's not in the court file. I don't have any documentation about any of this. I'm hearing it all for the first time today. Vashti, any input from you? I mean, frankly, I'm going to proceed forward with my original plan on extending the emergency minor guardianship as stated through next week when the trial was originally supposed to take place. And I'm going to reset this for a review next Tuesday, the 11th, with Commissioner Nelson. So you all would come back to this emergency or the minor guardianship docket next Tuesday. If there's things that need to be filed between now and then, please do so. So that's my original thought, is because we have this trial set. You all will be with Judge Hahn at 11:30 on readiness. Obviously, things will have. Sir, please mute. So you all will be with Judge Hahn at 11:30 for readiness. I assume the case will not be called ready. But since this proceeding is taking place first, all I can do is proceed forward with the fact that a trial is set for next week. The other I guess thought, and then I'll turn it over to you, Vashti, for input, is that I do not believe that Mr. Hubsky has any legal entitlement to hold the minor at this time. So do with that information what you will. But I think you're putting yourself in pretty shaky legal ground by taking the position that you're taking, Mr. Hubsky.
And I don't see why you feel that way.
Okay. Well, I'm not asking you a question. I'm telling you something.
Okay, and I'm responding.
Vashti, any input from you on proceeding today?
I just want to make sure Angel gets an attorney. That's like first and foremost.
Okay.
I think that's really important because and she needs that. I talked to her about it before, and then yesterday when we talked again, she said, "Well, then I didn't want it, but now I do." Totally understandable. She's totally understandable. So I really want to push for that. I know I told her it may take a little bit longer than she probably would like, but I think pushing it out until next week so that any documents can get filed, we can kind of move forward from there. I think that Rose, Nancy, and Angel need to be able to sit down and have a conversation together and make a plan, but she won't stay long enough for that to happen. So she's been through a lot as a kid, period, a lot. And she's used to being on her own and doing her thing. And I understand that, but she's 17. They just want to prepare her for when she's 18 in November. If we push this out anymore, by the time we're done, she'll be 18.
Yeah.
And Nancy and Rose just want to get her set up. They want to get her death benefit set up so she can have that income to do something with. They want to get all these things set up, but every time we get right there, something pops up and they're not able to do that.
So what I'm going to, thank you, I appreciate that input. What I'm going to do here today, first of all, is I note that the emergency guardianship ends April 8 of 2023 based on the current order. I am signing a new order pursuant to RCW 11.130.225 subsection 7 that allows this court to extend an emergency guardianship pending the outcome of a full hearing under RCW 11.130.190 or 0.220. So what I'm going to do, I have reached out to court administration. As of our hearing right now, the trial for the full hearing is set for the week of April 10th. That trial could take place anywhere between April 10 and 14. So I'm going to put in this new order that the emergency guardianship per the statute I just recited is extended through April 14, 2023. Then I am going to set a review in this guardianship case for, if I can find I'll just write it in here. We're going to do a review in this case for next Tuesday, April 11. before Commissioner Nelson at 10:30 a.m. At that hearing, my hope is we'll have a little more clarity about where folks stand in relation to this action. If there's been further filings, Commissioner Nelson can deal with it. Also, I am going to, as soon as we are off the record, I am going to orally state that the court will do its best to find an attorney for the minor. And we will make, court administration will make a couple calls to the 2 attorneys we know are taking these types of cases. And if one of those 2 attorneys can sign on to this case, I will sign an order ex parte to that effect. If we cannot, then we'll readdress that on Tuesday at the April 11th review hearing.
There is a scheduled trial, evidential hearing on the 10th at 8:45 scheduled.
So it's the week of. So
well,
I triple checked that before we got on today. And I did check with court administration, and it's set for the week of April 10th, even though they give that distinct.
Gotcha. Okay.
Yeah. So at today's readiness, or by Thursday of this week, if you folks were actually going forward with a trial next week, you would get a specific date, and it probably wouldn't be Monday. So that's why this order is going to go through Friday, April 14th, because that would be the last date the full hearing would take place if you were moving forward with it. Any other questions?
I have a question. Do I need to be taking Angel to Rose or Nancy's home today?
Well, sir, what I would say to you is this, and again, because of the role I am in today, I cannot give legal advice. What I can tell you is that you are not at this point any sort of legal guardian of the minor. Rose and Nancy are, and they are requesting that the minor not be with you. So I can say that.
Okay.
And I think you can probably piece that together from what I've just said.
Even though they've been willing to let her stay here for the past few months.
It sounds like they're revoking that authorization,
Right.
much like any parent or guardian could do at any time.
Because I wasn't agreeable with her bouncing back and forth between 2 homes. I wanted her to have 1 home. And I think that although I think Nancy is a good person and I think Rose is a good person, I also think I'm a good person.
Then you should make a filing. That is what needs to happen, right? So
I get
at this point, you don't
that suggest all these negative things about me, and she hasn't met me or been thorough in the background check. And that's why Angel and I are sitting here feeling like something's wrong.
Okay, sir, I understand where you're coming from, but at this point, you don't have legal standing in this proceeding. I'm actually giving you a lot of latitude to speak here today, and I don't have to. So what I'm trying to impress upon you specifically is, if you want legal standing, if you have concerns about this minor child and you have the best interest of the minor child at heart, then file something so that the court can make a determination. Because right now, the legal guardians for the minor child get to dictate these things that you are asking.
Okay.
And hopefully, again, with appointing an attorney for Angel, that things become even that much more clear. And I appreciate the GAL's involvement in this case and helping us navigate today's review hearing.
Yesterday was the first day she was aware that she had access to an attorney.
Well,
and I had to ask Vashti that. She did not give me that info. I had to call my sister. She's a head paralegal, and she helped me yesterday. And that's the only reason why we even brought it up.
So certainly anytime minor guardianships come through this court, that is something that is always discussed. I was not the commissioner who heard this case, but I can all but guarantee this isn't the first time that the right to an attorney has been discussed in a legal setting. So I understand that there's a lot of information flying around, and perhaps it was not heard or received or comprehended. That I can certainly understand. But the right to counsel is an integral part of all of these proceedings from step 0 to 100.
So is the services that Angel
Okay,
gets,
sir, I'm giving you a little more latitude than I need to. So what
Okay,
I'm gonna,
I won't say
hold on,
anything anymore.
hold on. I think that we've accomplished what we need to accomplish today. I've set a new review date for April 11th. I've extended the emergency guardianship to Friday. I've made it clear what my stance is on where the minor needs to be at this time. And I'll just remind the parties to log in at 11:30 to the readiness. Well, and that would specifically include the legal guardians, those folks who would be part of the trial. Log in at 11:30 for readiness. I will try to reach out to Judge Hahn if I can ahead of time to give her a little background on what's taken place here today. So she can help formulate a plan for the actual fact finding.
I'm clear on the time, not the date. 11:30 to the resident.
Today.
Today at 11:30.
Today at 11:30, and it is also by Zoom.
By Zoom. Okay, is there a
Okay.
link that I can get for that?
It is on the Cowlitz County Superior Court website as well, and it's called Universal Readiness. I'm going to finish filling out this order per my oral ruling, and I'll get this.
Are you guys clear on how to go on the Cowlitz County Universal Readiness website? Because
Okay. So I'm going to finish filling out this order per my oral ruling. I will get this filed with the clerk. The court admin will start working on an attorney for the minor. Anything else we need to accomplish today from Rose, Nancy, or Vashti?
Nope, not for me.
I don't have anything.
Okay. All right. Thank you all for your time. You're free to log out. Thank you.
Thank you.